All right, and we're live. Well, good morning, everybody. Thank you for joining us. Happy St. Patrick's Day. My name is Eric Tonsul, and I'm being joined by founding equity shareholder Marc Markel and associate Melissa McLain. And we're going to be talking to you guys about COVID-19 insurance and contract issues. But before we get started, a little disclaimer as always, the information presented today is as it exists as of today. The information is for educational purposes only and does not constitute legal advice. If you need legal advice for any of the topics that we discuss, please contact your legal counsel.
Hey, Eric, before you move on, you said it was good as of today. Those folks are meeting in Austin. Do you think they're trying to do something to help us or hurt us today?
That's a good question, Mark. I don't know. It's a little bit of a civil war going on in Austin as we speak. We'll talk about that a little later.
All righty.
But in any event, so again, those are our beautiful shiny faces. And our agenda today is as follows. We're going to be talking about what we've learned this year in the year of COVID, policies and procedures that should be continued by associations, current COVID-19 related restrictions, steps and procedures to reopen the pools in 2021. We've been getting a lot of questions about that already. So that's why we're having one of the main reasons for this webinar, to give you guys some guidance on that issue. And then Mark is going to do a very good presentation on insurance related contract issues. Very important that you guys are familiar with the topic and subject matter that Mark is going to talk about. It's very important to you guys. So with that being said, I'm going to hand it over to Melissa, and she's going to kick us off. Go ahead, Melissa. Thanks.
Thank you, Eric. Okay, today I'm going to revisit GA26, the order that was passed by Governor Abbott. I'm going to also look at GA34, the current order passed by Governor Abbott, and then kind of revisit those guidelines issued by the CDC. First, let's look at GA26. Now, GA26 was passed back in June of 2020. In this order, Governor Abbott signed limiting businesses to 50% of their normal operating capacity, which included pools. And when the capacity was limited, we were implementing social distancing, keeping groups of people 6 feet apart that were not related in the same household. They were also asking people to wear masks and clean and sanitize pool furniture and such. And fast forward to March 2nd of 2021, Governor Abbott passed G34. Now G34 rescinded G26. It allowed businesses to open at 100%, and it does not require a statewide mask mandate. Now, there is an exception to this. The exception is in counties with a high hospitalization rate, which is defined as 15% of all hospital capacity in that county as being COVID patients for 7 consecutive days or more, that the county judge may use COVID-related mitigation strategies. Now, in this order, the governor strongly urges everyone to still wear their mask. He also strongly encourages everyone to follow the Texas Department of Health Services recommendations, which these recommendations mimic the CDC guidelines. Now, in this slide, I have included a link to the State Department's Health Services for your review. Now, at this, they recommend to follow the CDC guidelines for pools. Now, let's revisit some of what those guidelines are. First, they would like everybody to maintain a healthy environment. What is maintaining a healthy environment? First, at pools, you should have defined physical barriers and guidelines. The CDC recommends that there will be markings at the pool showing what 6 foot of social distancing would be, or lines in the water. They also recommend that you clean and disinfect pool furniture, highly used items at a pool, or if there's a restroom at the pool, consistent cleaning, disinfecting of knobs, of floats, pool furniture, and also to keep a chart on documenting the disinfecting, keeping documentation and cleaning furniture between uses, and also encouraging not to share objects. One of the things is encouraging residents to bring their own furniture instead of using the furniture of the at the pool. Continuing, the CDC also encourages social distancing. Households, if people aren't in the same household, maintaining that 6 feet barrier. Also having a reservation system still in place, staggering the use of the pool. They also, if it's possible, if there's more than one entrance or to the pool, assigning a separate entrance and exit. If there's only one pool. The exceptions to social distancing would be if CPR needed to be administered or first aid should be administered. And also in case of an emergency, if you needed to evacuate the facility or pool, social distancing guidelines don't have to be followed at that time. The CDC continues to recommend that everyone wear a face mask when not in the water. This doesn't include goggles. Goggles would not be considered an appropriate face mask to wear outside the water. And the face masks are not recommended for children 2 and under. Hand hygiene. The CDC still recommends that everybody wash their hands. If you're at a pool that is not staffed, it is recommended that hand sanitizing stations are still in place and that there is cleaning disinfectant for everybody to disinfect the pool furniture as they come and go. Continuing, let's see, what else? If you are at a water playground or a splash pad, these can be peppered throughout the association, not just at the pool. The CDC recommends that there is signage which would also tell the dangers of COVID and also recommendations to further social distance, to use hand sanitizer, wash your hands thoroughly, and to wear a mask when you're not in the water. And again, children under 2 shouldn't be wearing those masks. Shared objects. The CDC recommends that the objects not be shared, such as pool noodles or pool floats. Encourage residents to bring their own. For more information on the CDC guidelines, we've included a link for everybody to view. Let's see what else we have. So in the end, what we recommend to follow the CDC guidelines, which is regular cleaning and disinfecting. I can't emphasize that enough. Wearing masks when not in the water. When at a pool that is not staffed, to have hand sanitizers for your residents available and cleaning, disinfecting, and also signing waivers to use the pool and facilities. And then if you have a reservation system or the capability of a reservation system, still doing the staggering use of the pool. This will help with social distancing and keeping everybody healthy and safe. I'm going to pass it on over.
All right. So from what Melissa has told us, the governor has rescinded the mask ordinance. I want to make sure I get this right, Melissa, because it was confusing to me. Rescinded the mask ordinance, but at the same time said you should still wear a mask and you should follow CDC and Texas Department of Health guidelines. So what he's done is absolutely nothing, because everything that we did last year with reservations and pool furniture and everything else is still what's recommended to be done at our facilities. correct?
Correct. Even though the governor has rescinded these guidelines in the state as far as not having a statewide mask mandate and letting businesses open up to 100% capacity, he is encouraging that we continue to wear masks. The COVID's not over. The threat is still there, and he is strongly encouraging that we continue with the safe practices we have been, which is wearing masks, washing our hands, using hand sanitizer, social distancing. If you're sick, stay at home.
Right.
The normal things. Although he's not requiring it, he's highly encouraging it.
Right. But Bubba is going to the pool on Tuesday, and he's going to say, "The hell with you. The governor said I don't need to wear a mask. I'm coming in. I'm not wearing a mask." What's the association to do? Maybe Eric or somebody chime in on this. I know we have a program but I really want to get some practical information out. I see this happening. Governor Perry said, "I don't need to wear no mask. I'm not wearing no mask."
Well, you're stealing my thunder, Mark. But
Sorry, I was all excited. I was listening to Melissa, and I was getting riled up here for some reason.
So I'll touch on that at the end of the presentation.
These folks that are on, there's 20 people listening to us. What do they care?
So the order specifically says that businesses and establishments have the right to impose their own COVID-related rules and regulations. So that applies to associations. So even though the GA34 rescinded all the COVID-related requirements in Texas, we can still, as an association, adopt rules regarding COVID-19 safety measures. And again, I'll go into all that later on in the presentation, but we do have the authority and ability to do that, and I'll talk about it a little bit later.
I just want you to talk also not just about the rules, but on the enforcement, if you could do that later.
Sure.
I'll give you a heads up, so you got about 10 minutes to figure it out. Just kidding. Hey, first of all, let me say I appreciate the folks who attended. We have over 300 people in attendance today at our webinar. And this is information which hopefully you can take back and use in your communities and in those communities that you manage. And what's important to me is that we have some good takeaways. And so they asked me to come and talk to you a little bit about insurance, specifically as it relates to the pool. So for those of you who use third-party pool companies for maintenance and for lifeguards, we want to make sure that the pool contractors that we use have sufficient insurance. And what is enough and when is enough, it really depends upon a lot of things. And I'll talk about that a little bit when we talk about the certificate of insurance. What I did want to talk about was the differences between admitted and non-admitted carriers and ratings. There's insurance companies which are very, very solvent, and there are those that are just very solvent, and there are some that are barely solvent, and they're rated by agencies. S&P and Best are rating agencies that rate insurance companies, so you can actually see where they sit in the realm of stability. The difference between an admitted and a non-admitted carrier is the regulation by the state of Texas. Your admitted carriers, if they were to have a financial failure, would be backed by the Texas State Insurance Guarantee Fund, whereas a non-admitted carrier, if they failed, you'd be left holding the bag with nothing other than a piece of paper that said, well, I thought the pool company had insurance. But let's move on to the next slide real quick. All right, so this is where I'm going to spend the bulk of my time. There's 4 slides here, and they are a certificate of insurance, which is generally a 2-page document, but I blew them up and had them split apart to where we can actually see them. And what's incredibly important is that you read this. People have gone blind to forms, and just go to the fill in the blank parts, okay? So if you look at it, that this tells you it's for information only and confirms no rights upon the certificate holder. So because it has the association's name and the certificate holder blank, the first sentence on the COI tells us it has no meaning whatsoever. Doesn't provide any coverage, and the certificate does not constitute a contract between anybody and the certificate holder. So there's no responsibility to you. This is just a snapshot in time when this document was issued. So this one here, if you look, was issued February 22nd. Carriers make a representation on that date. This carriage was in effect. All right. So let's go down. The producer is the name of your broker. Make sure it's in there. That's kind of important. But what's really important is the name of the insured. If the insured name doesn't match the name in the contract with your pool company, then the insurance is not applicable. Okay. It's just, I can't tell you how clear it is. If it's ABC Pools, but they're doing business as Sunshine Pools, and your contract is with Sunshine Inc., you're probably not going to have any insurance from this certificate. You want to get it fixed to where it lines up. Now, just above the producer are some more words. It says important. Well, that generally means that you should read it. If the certificate holder is an additional insured, and we're going to talk about that, and they should be, the policy must have insured provisions endorsed. And I'm going to teach you that. Also, subrogation waivers. We're going to go over that. A statement on this certificate does not confer rights to the certificate holder in lieu of the endorsements. So unless you have an endorsement for a waiver of subrogation and additional insured, you have absolutely nothing. On the right-hand side, you can see insurer A, B, C, and D. These are the insurance companies that are providing the different insurances, which we'll look at on the next slide. But you want to make sure that you're familiar with these insurance companies. What's their best rating? What's their S&P rating? Are they admitted or non-admitted carriers? You can check that by going to the State Department of Insurance website, putting their names in, and they'll give you an indication. All right, let's go to the next slide. The next slide is actually the insurance itself. The ABC, you can see that in the first column to line up with the company name. But I want to go through each of these four coverages in a little bit of specificity. If you look at the commercial general liability insurance, you'll note that it's an occurrence policy. This means it covers all covered claims during the policy period. Policy period is shown just to the right. Policy period on this GL policy is May 7th, 2020 to May 1st, 2021. If your pool's not going to open until Memorial Day, you don't have any evidence that there's going to be insurance in place, because this policy is expiring on May 1st. And so you have no assurance that these insurance companies are going to renew this coverage at this amount or a higher amount or a lower amount. So that's one problem right off the bat. The other thing is look over to the left, the third X down, it says general aggregate, policy, and project. That's important. When you look at that, it's going to show you to the far right what the coverage really is. So each occurrence is $1 million. That means you have one drowning, one event at a swimming pool which causes an injury. The maximum the company is going to pay is $1 million under this policy, and that is a depleting policy. So if there are defense costs involved, the defense costs come off the top, and whatever you got left is what's going to be available. The general aggregate is $2 million. What's that tell me? It tells me that I can have two claims up to $2 million general aggregate, or four claims of 500, whatever it is. I can't spend more than $2 million. That's all they're giving me, including defense costs. So now we understand what our project limitations are. The next line is problematic. It's the all project aggregate. This is telling us that they have $5 million across all of their projects. Well, your pool company may have 20 different associations that it's working for. So once the 5 million is gone, there's no more insurance. Your 1 million, 2 million is worth zero. Okay, so you want to make sure that you know how many pools are they monitoring, how many associations are they working for, to decide for yourself whether $5 million is adequate or not. I'm going to skip auto insurance. It's really not all that important as long as it's there. But I do want to come down to umbrella liability. And the umbrella liability is also an occurrence. It's what we call a following form. So whatever is covered under the general liability insurance should be covered under the umbrella. Well, we got $2 million for each occurrence and an aggregate of $2 million. Well, that's all peachy keen. Because we're thinking that's for our swimming pool that we just contracted with. The answer is no. This is for all of their pools. So this pool company has an aggregate total general liability insurance of $7 million. I can tell you that the demands in the drowning cases that our firm is working on are $10 to $20 million for, and a drowning is not necessarily a death. A drowning which results in a brain damaged child, $7 million will not cover your cost. And so the association's insurance is going to be at risk. This is probably the most important part of this insurance policy. Now, let's look at the little bitty words at the bottom, and that's the blanket additional insured form. So there's going to be a form attached that states that the association's an additional insured. Absolutely, positively look at the form, not just the COI. The name has to be right. If the name of the association is ABC Community Association, Inc., and it just says ABC, the insurance company may have an issue, okay? Sometimes it's totally wrong because they used something from a different association. Make sure that that insured is there. The next line gives you a blanket primary and non-contributory form. Blanket primary means that if the association's insurance and the pool company's insurance both would be available to pay because they both have coverage, that the pool company's goes first. And non-contributing means that even if there's negligence on the part of the association, it wouldn't contribute to any settlements unless and until the insurance of the pool company is exhausted. And then the waiver of subrogation form says that once the pool company pays out a claim, they're not going to come back to the association to get their money back due to the negligence of the association. So this is incredibly important to read. Some people just skim it because it says, well, our contract called for 1, 2 plus 2 on the excess. It's here. Well, it may not be. And I think that association is going blind into these situations, not knowing that this pool company has $7 million to cover any and all claims for the entire policy year. And the fact that this isn't even the policy that's going to be in effect during the pool season. So keep all that into account. Let's go to the next page, please. Certificate holder, once again, make sure the name is accurate, okay? And then read the cancellation block, okay? In your contract, you probably say if the insurance is going to be canceled, you're going to give me 30 or 60 days notice. Ain't going to happen, all right? Should any of the above described policies be canceled before the expiration, notice will be delivered in accordance with the policy. The policy says they're going to give notice to the named insured, not the additional insured. So you need to have some type of a monitoring device, if you will, that this is in place. Let's move on. All right, so this is the additional remarks schedule, and it has the forms that we talked about, also for excess liability. So we have it for general liability and we have it for excess liability. So the form is good. It's just the dates are a little hinky, and I'm not certain that that amount is enough. Maybe if they only are guarding 2 or 3 association pools, it would be okay. But if they're doing 10, 20, there's no way that that's a sufficient amount of insurance. Let's move on. All right, so how do you make sure that you're telling the pool vendors what it is that you want ahead of time? You use an MSA. And the master service agreement for pool, specifically dealing with the insurance issue, will set out all of the requirements that we're talking about. If you don't want to do a master service agreement, but you just want to get an insurance schedule, talk to your broker. They're going to hate me telling you this, but they'll put out on a sheet of paper for you what you need to make sure your vendor for different services has. It's different for the guy fixing the pothole than it is for the people that are guarding your 16 swimming pools that have slides and high dives and climbing walls and all this other stuff, okay? So be ultra cautious and tell them you're not trying to kill the vendor, but you're trying to be in a position where you can protect your association. Make sure that it talks about primary not contributing. Make sure it says waiver or subrogation in it. And if you don't understand what those things are, even after this presentation, feel free to reach out to me. Okay, I love talking to people, so I'm glad to do that anytime. And I think that's my last one, but maybe not. Lindsay? Yeah, I thought so. Eric, it's all yours, but I do have questions for you at the end of your presentation.
All right, sounds good. Thanks, Mark. All right, so what does all this mean for associations? What do we do going forward? So Melissa already kind of touched on this earlier on, but again, CDC guidance is still in effect, and that's at the federal level. And so CDC guidance is the way we've been living for the past year now. Wearing masks, social distancing, all that good stuff that we have come to know as the new normal. And in fact, again, GA34, which is Governor Abbott's order, encourages, as Melissa said, encourages individuals to continue social distancing and wearing masks and that kind of thing. So our recommendation is that for associations at their amenities or on their property, that you still continue to follow the CDC guidance and to require masks and social distancing when on association property. As far as the county judge authority goes, this is kind of unique. According to the order, most regions in Texas, the county judge or the mayors do not have the authority to adopt local level restrictions with regard to COVID, unless you're in a region where their COVID patients are at 15% capacity of the hospitals. So, and those are few and far between for the most part. The county judge or the mayor of that area will not have the ability to implement local level laws. Next slide, please. Now, that being said, Austin and Travis County seem to feel otherwise. They decided that the governor's order was cute, but it wasn't. They weren't going to follow it, and so they both the city of Austin and Travis County adopted mandatory mask ordinances and occupancy restrictions, and that was effective, March 10th when the governor's order went into effect on March 10th, and so on March 11th, the Attorney General Paxton filed a lawsuit against Austin and Travis County. So we'll see how that plays out. Again, that lawsuit's only a week or two old, but more than likely, if I was a betting man, I'd probably put my money on the Attorney General on that one, but time will tell how that's going to play out. But nevertheless, we cannot rely, so when I say we, I mean associations really can't rely on local or state government enforcement of these restrictions. So what do we do as an association? Well, the board of the association needs to determine whether or not it's in the best interest of the association to adopt COVID-related rules. And so now we're going to talk about that. Next slide, please. So again, as I mentioned earlier, when Mark stole my thunder so rudely at the beginning of this presentation, the order specifically states that businesses and establishments, it doesn't prevent businesses and establishments from adopting these safety measures. So if the association wants to adopt rules regarding COVID-19, since the state regulations are no longer in play, you need to make sure that your rules are adopted in compliance and in accordance with the property code and your governing documents. Next slide, please. So how do we go about doing this? For condos, there's a statute in 82-102 that specifically provides general rulemaking authority for condominiums. And it does not matter if you're an 81 or an Chapter 81 or Chapter 82 condo. For those that don't know, Chapter 81 of the property code applies to condominium associations where the declaration was recorded prior to January 1st, 1994. Chapter 82, which is known as TUCA, which stands for the Texas Uniform Condominium Act, relates to associations where the declaration was recorded after January 1, 1994. Now, that being said, there are some provisions in TUCA, Chapter 82, that apply to Chapter 81 condos. 82.102 is one of those provisions, so it applies to both. So the general rulemaking authority does apply to both 81 and 82 condos. Now, for single family residential and townhome associations, there is not a similar statute per se. I'll address that per se in a second. So you will need to get with your legal counsel to determine whether or not the governing documents give you rulemaking authority. Rulemaking authority is not automatic. It has to be set forth in your governing documents. If not, it may require a vote of the membership in order to adopt these rules. Now, I said there's no statute per se because actually in Chapter 204 of the Property Code, which applies to Harris County, Montgomery County, and Galveston County, it does allow for general rulemaking authority. And so you may be able to hang your hat on that depending on what you're trying to do. But again, don't just say, oh, we got it under 204 and go forward without consulting your legal counsel. You make sure you do it right. So make sure if you do attempt to adopt a policy or rules or regulations under 204 that you consult with your legal counsel. And then last but not least, Chapter 202.06 of the Property Code states that any dedicatory instrument must be recorded in the county where the association is located in order to be enforceable. This is important. You don't want to spend the time, money, and effort adopting these rules and regulations, and then you're not recording it. It's not enforceable. So, and that doesn't only apply to these rules and regulations. It also applies to if you amend your bylaws, for example, and you do an amendment to your bylaws, but you don't record it, that bylaw amendment is not effective unless or until it gets recorded with the county. So make sure you guys are doing that. Next slide, please. And so I actually go back to the previous slide, and I'm going to address what Mark had asked me earlier, and that's about enforcement. So let's say we do adopt COVID-related pool rules, and so now what do we do about enforcement? Bubba comes to the pool and he refuses to wear a mask. What can you do? Well, if you've adopted a pool rules that require that mask be worn while you're not in the water and that kind of thing, well, now again, those rules are a dedicatory instrument, assuming that they had been recorded like they're supposed to be, they are enforceable. So you have your regular enforcement mechanisms as you would with your other rules that you have. Now, whether that be you send a deed restriction violation letter to this owner, if your rules say that if you don't comply with these rules, you can be escorted from the facility or not permitted access, you can enforce that. Or if you have fining authority in your governing documents, you could potentially levy a fine against somebody for not adhering to the rules that were adopted on behalf of the association. So those are some options, ins and outs as far as what you can do with regard to enforcement of these rules as it relates to, in this case, the pool. All right, next slide, please. So what about the rules that were adopted that associations had already adopted prior to GA34 going into effect? Are they still applicable? Do they still continue? And I apologize for the lawyerly answer here, but the answer is it depends. And it depends on the language in your rules. Was there any language in your rules that said, this policy, these rules shall be in effect, and there was no statement at all with regard to when they would no longer be in effect? So in that case, there's no sunsetting provision in those rules, and those rules would still be applicable. Whereas there may be a language in the rules that states that unless or until the rules will automatically expire upon the expiration of any federal, state, or local governmental mandates. So if you have language like that, well, we know there's no state mandate anymore. There's no local mandate unless you're in Austin or Travis County right now. But the federal is still applicable. You still have that CDC guidance. And so if you have language like that, an argument could be made one way or the other as far as whether or not those rules are still in effect. And so our recommendation is that if you have rules like that you've already adopted, and they may have similar language to what I just stated, that the board consider adopting a resolution or some other type of instrument which makes it crystal clear as to what the intent of the association is with regard to those rules, whether or not you do intend to have them still in effect and still applicable to the owners and patrons that visit the pool, or if you're going to get rid of them altogether. It would be a lot cleaner and easier if you had a document providing clarification as to what the association's intent is with regard to the rules that have already been adopted on behalf of the association. And again, that doesn't only apply to pools. We did plenty of rules for clubhouses, for parks, for basketball courts. So a document needs to be, or it's highly recommended that a document be drafted that addresses all the rules, so there's no confusion, there's no issue, there's no ambiguity with regard to whether or not the rules are in effect. And then lastly, does the governor's order change an association's potential COVID-related liability? And the answer is short and sweet, no, it does not. The virus still exists. We did not all become immune on March 10th when GA34 took effect. The potential for contracting COVID and dying of COVID still exists, as we all know. And so for that reason, if somebody contracts COVID at the association property or their amenities or whatever, and they, heaven forbid, but they pass away, you're probably going to get sued. Let's just be real about that. Now, filing a lawsuit and prevailing in a lawsuit are two totally different things. But you might beat the rat, but you're not going to beat the ride. And more than likely, there's not going to be any insurance covering pandemic related claim like a COVID claim. So you're more than likely going to be paying out of pocket for the defense of that lawsuit. So yes, no, the liability does not change just because Governor Abbott signed GA34. So that is all I have. Mark, you said you had some questions for me you wanted me to answer.
Well, I have been answering questions for some of our attendees who have filled out some Q&As.
Okay.
I can say generally, I'll bring up either Kyle or Lindsay to answer the question, but our recordings of these generally get posted on our YouTube channel just a few days after. I think Kyle and Lindsay fixed some things like shadows on our nose or our makeup issues, or potentially change your tie color. Okay. But other than that, the data, the words are going to be posted up on our YouTube channel just shortly, and that attendees will receive a copy of our slide deck. Slide deck is good as a refresher to those who attended. Sharing it with others, probably not so much, because there's a lot of words that go beyond the slide, and without the words, the slide really has a whole lot less meaning. So I'd be cautious of that. I do want to amplify what Eric said. I do not believe there's going to be insurance for claims relating to the virus. But even if your policy had it at one point, all of the new policies coming in will not only use the word virus, they're going to start using pandemic and epidemic. And once an insurance company finds that there's something in their policy that requires them to pay, that's just going to go away. And really the only way to protect yourself is to do what Melissa and Eric have said. And that is, if you follow the most conservative approach, if you're sued, you have the best defense. All right. So what's the best approach? Is it saying, well, we're just going to close it, lock it up? No, that's really not the best. That hacks off all the owners. Setting it up in a way where it operates cleanly is probably the best approach. To bring your own furniture that Melissa talked about, making sure that everyone wipes down surfaces. Those are all incredibly important. And, if you don't have a monitor, if you don't have a lifeguard, you're not going to be able to do a lot of this. And some of the questions were, well, what's the point? Well, the point is that you're pushing that onus back to the member who's going to the pool. If there's still a sign on the pool that says, we have rules, okay? Here are our rules. Now, we can't enforce them if we're not there. So why don't you just put, we highly recommend that you do the following. Okay, it's for your own safety. I have some associations that have a sign that's pretty skull and crossbones that says that you entering this facility, you could expose yourself to a virus, you could die. Okay, and so that might be the other extreme. There is no one fix for all of the communities. So the best thing you could do is come up with what can work for you. And also economics come into play. We have Say Our Pools, spoons your own risk pools. And they don't have money for a pool monitor. So what's the point of putting up socially distance? Well, we're putting that onus back on the individual owner. We're telling you to socially distance. Don't gather in groups of more than whatever. And when you have fights with people, don't confront anybody. My gosh. Worst thing you do is say, well, how about this Smith & Wesson telling you to get out of the pool without a mask? You don't want to do that. If someone is violating a rule of the association, they're committing an act of trespass if they don't leave. Okay, leave law enforcement to law enforcement. And so there's phones at every swimming pool, 911 phone or whatever it is, and make sure that you tell your folks that are doing it that you don't want them engaging in confrontation. That's a lot of what's going on here. Eric, one of the questions that just keeps coming up over and over again is waivers. Are they going to hold up in court? What do you think?
Well, there's no 100% ironclad waiver, Mark. There's just not. And anybody can challenge the validity of a waiver, but it's good to have because again, without it, there's absolutely nothing supporting your position that that the owner was using the pool at their own risk. But again, I'm not going to sit here and say that a waiver is 100%. You just hold it up and okay, we're done. Summary judgment. No, that is not at all what's going to happen. But it does provide a layer of insulation for the association in the event of a lawsuit.
All right. I will add though, waivers for minors are really kind of sketchy. Okay. Because the parent doesn't necessarily have the right to waive some of the claims of a minor. Also, I've seen waivers that are not enforceable. Okay. Some plumbers know how to lay plastic pipe, some know how to lay copper, and some can sweat a good copper pipe and get a good sink. Some attorneys can draft a waiver, and some attorneys can draft a waiver that has more bulletproof. Okay. And you have to think this through. If it doesn't contain specific negligence provisions, if it doesn't contain all the things that you want it to contain, that the law allows it to contain, in the right font size, in the right boldness, in the right sections, and I've seen attorneys that draft the dang thing, the whole thing is one sentence, bold and capitalized, worthless. Okay, and so make sure that you ask your attorney. And attorneys have insurance, by the way, if they screw up. Maybe I wasn't supposed to say that, but if ask them, is this waiver going to help us if we're sued? And if they could say, well, maybe, as opposed to, well, yes, so long as it's not this, or this. If they tell you that a waiver is good for a minor, well, then they're probably telling you that it has an indemnity by the parent, which means that if the minor later sues, the parent's going to indemnify. If the parent doesn't have any assets, there isn't going to be any indemnity dollars. So there's no way to guarantee that a minor's waiver is going to be effective, but it's still a good deterrent. All right. Do we have time for more questions? It looks like we have a couple of minutes. Let me, have y'all been going through the Q&As? Is there anything that we haven't touched on?
Yeah, I was going to, Mark, there's a question from Ms. Branham. If an association had a waiver signed last year, is it advisable to complete a waiver again each year before issuing wristbands? It depends on what the language of the waiver that was signed says. If there's no sunsetting provision on it, I would say you're okay with a waiver that was already signed. But if there's some kind of expiration language on that waiver, then obviously, yes, you need to have another waiver executed before issuing the wristband.
And then have the conditions changed? Did we have different rules last year than this year?
Well, that's a good point.
Even though the waiver may still be good, they were waiving their rights based upon known conditions, and the known conditions changed. So if the known conditions last year, we were going to say, hey, bring your own chair, do this, do that, social distance, only 50%. And this year we're saying, hey, just come on in and have a great old time. I would presume that I would want to have an updated waiver signed upon the present conditions, or an acknowledgement, something. I think that would be a pretty good idea. Okay. How many people have filed claims in the last 12 months? I don't know. Do you know, Eric? I'm not personally aware of one in Texas, but let me tell you what I am aware of in Texas. People making claims that the facilities have not been accessible to them, and therefore they should have paid less assessments. And we filed a lawsuit to get our money back or get a reduction in our assessments for next year. None of those have come to fruition yet. And I would take the position that, hey, we still had to keep the electric on. We still had to treat the pool. We still had to make sure that everything was sanitary. And the only thing we didn't do is have a lifeguard. And hell, we didn't have one last year anyway. So it's the same cost of operation. Or say, even if there is a reduction in cost of operation in this year, it'll be reflected in a future year's assessments because we're not allowed to have profit. If we have profit at the end of the year, what do we do with it? We give it over to the reserve account. So I don't know too many associations that are overfunded on reserves. So that's probably the most frequent issue that we've had related to COVID. Not aware of any others. Okay, using a pool at their own risk with no waiver, no, doesn't work. because it doesn't have the specific negligence and other provisions that you'd want in a waiver. So if you use at your own risk, that means that if the association is negligent, let's forget COVID, use the pool at your own risk. Well, the association knows that the pool deck has a problem and doesn't disclose it. Latent defects, patent defects, knowledge of any negligence on the part of the association, all of that would be in a waiver, but it wouldn't necessarily be in a sign that says swim at your own risk. So big difference between the two.
Mark, here's an insurance question for you. Should the third-party pool vendor have their own insurance? To clarify, we, the POA, should have the pool vendor listed in the POA insurance policy.
No. I wouldn't insure the pool vendor. No. I'd be sure that they have ample insurance, and our insurance protect us. The only reason why you do a cross on insurance policies if both parties have some responsibility. I'm assuming that the POA does not have responsibility for the pool operation. That's what we hired a third party for. Okay. Peter says that the coronavirus business link isn't working. Let's make sure that the one we have is working. We'll put it in the slide deck that's sent to everybody, okay?
All right. Should all guests fill out waivers besides the homeowner? And answer that is yes, if you can get it done, because as Mark said earlier, an owner can't waive the rights of somebody else. So yes, the best practice would be anybody who's using the pool to sign a waiver, of course, unless they're a minor, and again, with the caveat that Mark explained earlier. But that being said, anybody who uses the pool should be signing a waiver.
Yeah. Some associations have us adopted a no guest policy. You don't have to worry about it. If you have a say or a pool and the owner has the code and he brings in 30 of his closest friends, you're not going to get them to sign a waiver anyway. But so it's really just for the monitored facilities that you're able to control the signing of the waivers. Okay.
All right.
Anything else? No.
A lot of these questions are
here's one that's kind of intriguing. It says, we turned off all card key access for COVID. We're now requiring all owners to be current on their accounts and sign a new waiver. Hey, that's really pretty cool, but make sure you give them a notice and opportunity for hearing under Chapter 209 before you don't allow them to use a common element, because that will result in a lawsuit that's worse than a COVID lawsuit. It's one that they can actually win. If they've had their 209 notice and they're being denied their rights to their common elements.
And again, that's only applicable for single family and townhomes. 209 does not apply to condominiums, just as a point of clarification to you guys.
Thanks, I appreciate the asterisk. I often forget, but I don't even like letting people be denied use of things in condos, but I know we have the right to. All right, so we got a ton of questions here. I tell you what, Kyle or Lindsay, can you do me a favor and make a list of the questions that we haven't answered? And if they're ones that we really haven't addressed during this, I'm going to ask Eric and Melissa to respond to those, and let me know if you need my assistance at some point. But I think we're in great shape. It's 12:19 and we've done everything that we're supposed to do. I think that what you need to do is just be cautious, okay? Don't throw caution to the wind. Be cautious in your operation. And think about it in terms of, if this was my backyard swimming pool, would I leave my gate open and just say, everybody come on in and do what you want? Okay, let's be reasonable and make sure that the associations are reasonable, but also exercise good business judgment. Exercise the type of judgment, and if it's personal judgment, if it was your own money at risk for the claims that could come from it, how would you treat this facility? And think about that along the way. Melissa, any closing thoughts?
I just recommend or follow the CDC guidelines and stay safe. All
righty, thanks. Eric?
I just want to, again, thank you everybody for joining us. I hope everybody's doing well and staying safe. We appreciate you guys taking time out of your day to listen to us jabber up here, and hopefully it's been helpful. And again, if for those of you who who we represent. If you have any questions, by all means, feel free to contact us. We're happy to answer any questions you may have. And with that, hope you guys have a wonderful day. Thanks.